By now you've read the fourth and you've seen the slides and you've heard the government lies and you've wondered, how is this even legal? It's the third-party doctrine, a little bit of Supreme Court logic, where they held that if you share information with a third party, you have no Fourth Amendment protection whatsoever. This is true even if that party promises you confidentiality. The so-called logic, because the third party might breach confidentiality, the feds can force them to breach confidentiality. What this does is it conflates perfect information security with the concept of a reasonable expectation of privacy. And you know what? Not even the NSA can do perfect information security. In fact, when we share information with third parties, we don't just expect them to maintain our privacy, we demand it. But the Supreme Court has held that banking, accounting, and telephone records, you don't have any privacy interest in that information at all. And some courts have even held that medical records are records in which you have no privacy interest. The Masspionage that is being performed by the NSA, that is founded on the third-party doctrine, because when they tell you that these programs are legal, it's based on the third-party doctrine. The business records exception is all based on the third-party doctrine. And if the third-party doctrine went away, everything they're doing is unconstitutional. Real reform requires fixing the third-party doctrine. Any legislator who suggests some reform that does not address this is avoiding the issue, offering a fig leaf. We need a rule that says we retain our privacy rights when we share information with third parties. And the only way that's going to happen is if you demand it of Congress. So demand it now. Contact your representatives. Tell them, fix the third-party doctrine.